During the 4-hour-long Supreme Court ruling on digital migration Monday, a section read by Justice Mohammed Ibrahim caught the attention of Royal Media Services Chairman Dr. S.K. Masharia.
The licensing of citizen radio and television appeared to be conditional upon political cooperation between its owners and the ruling party, KANU. When it was not forthcoming or assured, the operator was switched off the air and the equipment vandalized. This court takes judicial notice of the corruption, cronyism and state patronage that attended the licensing of frequencies for radio and TV broadcasting.
Flanked by Royal Media Services Legal Officer Njenga Njihia, Dr. S.K. Masharia, whose media empire includes Citizen TV and Radio Citizen, expressed concern with the impression Justice Ibrahim's statement gave on how Royal Media Services acquired its license.
The viewers and listeners of Citizen Television and Radio understood that part of the judgment to mean that Royal Media Services Limited obtained its licenses corruptly, made a corrupt bargain which it broke and suffered for that breach of the corrupt bargain, and further that today it carries on its business in a corrupt manner.
Granted that in January 2000 and April 2001, the radio and television station of Royal Media Services was shut down and its equipment vandalized by the KANU regime, Dr. Masharia says he was not guilty of breaching political cooperation with the then ruling party. In fact, RMS, he says, went to court in 2008 to claim for the return of those equipment and for damages for the loss it suffered at the Court of Appeal from the government. The case is still pending hearing.
Royal Media Services Limited is greatly aggrieved by the fact that it was wrongly depicted by Honorable Justice Mohammed Ibrahim as a corrupt enterprise. It is not. It is taking advice as to its rights and will take the appropriate action after getting the advice.
Dr. Masharia explained that RMS obtained its radio and television broadcasting license in 1997 as a result of a judgment delivered by the High Court. At the onset of the case in 1994, the Minister for Information at that time, Johnston Makau, stated at a news conference that the government would not issue new licenses for private broadcasting in the near future, claiming that those who were pressing for liberalization of the electronic media wanted to use it to destabilize the government.
Honorable Makau stated that the executive arm of the government, not the judiciary, will decide whether or not Royal Media Services Limited would receive its license. He attacked the independence of the judiciary.
When Royal Media Services made an application in January 1995 for committal to jail of the Minister for Contempt of Court, the High Court allowed it. That ruling angered President Daniel Moi, Dr. Masharia says.
The president wondered how a lawyer could have the audacity of threatening the Minister of Information and Broadcasting, Johnston Makau, to be sued after he made it clear that the government was not going to license any private broadcasting station in the country.
The president's utterances further drove a wedge between the judiciary and the executive arm of government. That same year, in August, the court ordered Makau, on behalf of the Ministry of Information and Broadcasting, to consider RMS's application as required by the law. The decree was also served on Attorney General Amos Wako. They disobeyed it, prompting RMS to seek an order that the minister and the AG be committed to jail for at least 6 months for contempt of court.
In April 1997, when the said application was pending, Royal Media Services Limited was issued with the radio and television licenses. Consequently, it became unnecessary to prosecute that contempt of court application.
That sums up RMS's journey in search of a radio and TV broadcasting license. Sylvie Chebet for Citizen Business Center.